Welcome to a presentation by the Montana Human Rights Bureau on discrimination in Montana's public accommodations. Unlawful discrimination is when an adverse action is taken against an individual in a protected area because of their protected class. The protected areas under anti-discrimination laws include employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. For the purposes of this presentation, we will be focusing on public accommodations. These are the protected classes under the area of public accommodation. They include age, at any age, sex, which includes pregnancy, gender identity, and sexual orientation, race, color, religion, creed, mental or physical disability, national origin, and marital status. There are other protected classes under different protected areas in anti-discrimination laws. However, please note that these are the only applicable protected classes under Montana law in the area of public accommodations. The Montana Human Rights Act defines a public accommodation very broadly as a business establishment or place that caters or offers its services, goods, or facilities to the general public. The statute sets out many examples of places that classify as public accommodations, but notes that the list is not exhaustive. Some of the examples included in the statute are restaurants, hotels, trailer parks and campgrounds, bathrooms, and hospitals. While the definition of public accommodation is broad, the statute does carve out one exception: institutions or clubs that are distinctly private, including lodges of a recognized national fraternal organization. However, an institution will not be considered distinctly private, and therefore not part of the exception, if it has more than 100 members, provides regular meal service, and regularly receives payments for dues, fees, or the use of space or services by non-members. The Montana Human Rights Act states that it is unlawful discrimination for an owner, lessee, manager, agent, or employee of a public accommodation to refuse or deny a person the services, goods, facilities, advantages, or privileges of a public accommodation based on a protected class. It is also unlawful discrimination for the public accommodation to publish, circulate, issue, display, post, or mail a written or printed communication, notice, or advertisement that states or implies that any of the services, goods, facilities, advantages, or privileges of a public accommodation will be refused or denied based on a protected class. Discrimination in Montana's public accommodations can take several different forms. They include disparate treatment, or treating someone differently than everyone else because of their protected class, denial of service, printed notice implying or stating that service is denied based on a protected class, harassment by association with someone in a protected class, failure to accommodate, and in an indirect way, retaliation for opposing a discriminatory act or requesting an accommodation. We will now review these types of discrimination in public accommodations more closely. Disparate treatment cases allege that a respondent treated a charging party differently than others based on his or her protected class. The first step of a disparate treatment case is the prima facie case. Prima facie is a Latin term that means on its first appearance. The charging party must prove each element of a prima facie case to show that what respondent did, the adverse act, looks like discrimination on its first appearance. The first element requires the charging party prove that he or she falls under a protected class. Next, the charging party must show that he or she was subjected to some type of bad act by the respondent. And lastly, the charging party must prove that circumstances raise a reasonable inference that he or she was subjected to the bad act because of his or her membership in the protected class. Some evidence that raises a reasonable inference include that the adverse act does not happen to those who are not members of the protected class, or comments that suggest a protected class was a factor in the act. When analyzing disparate treatment cases, a shifting burden analysis is used. As we just covered, in the first step of analysis, a charging party has the burden of proving the elements of a prima facie case. After the charging party meets that burden, the burden then shifts to the respondent to produce a legitimate, non-discriminatory reason for the adverse act it took against the charging party. Once the respondent produces that legitimate non-discriminatory reason, the burden then shifts back to the charging party to prove that the reason proffered by respondent is pretext or unworthy of belief. In order to prevail on a disparate treatment complaint, a charging party must prove his or her case by a preponderance of the evidence. This means that discrimination more likely than not occurred. This standard is less onerous than beyond a reasonable doubt, or based on clear and convincing evidence. Rather, it is a 51% probability based on the evidence at hand that discrimination occurred. It is important to note that the Administrative Rules of Montana change this analysis a bit in the event that there is direct evidence of discrimination. When there is direct evidence, there is no shifting burden. Instead, the respondent must prove by a preponderance of the evidence that an unlawful motive played no role in the action it took against charging party. In the alternative, the respondent can prove that the direct evidence is not credible and unworthy of belief. Direct evidence speaks directly to the issue, establishing that discrimination occurred without support from other evidence or presumptions. An example of direct evidence would be a sign posted in a convenience or liquor store that tribal IDs are not accepted for making purchases of alcohol and tobacco. Another example of direct evidence would be a hotel manager stating to someone wanting to rent a room that they cannot stay there because of his or her disability. Now let's walk through a case example to show the shifting burden in action. A charging party filed a disparate treatment case with the Bureau against a hotel she had stayed in for several months. Walking through the elements of the prima facie case, charging party experiences a visual impairment qualifying her as a member of the protected class of disability. This satisfies the first element of the prima facie case. Charging party asserts that despite her request, her room was not cleaned in the same manner as other guests at the hotel, satisfying the second element, that she was subjected to an adverse act. When charging party complained that her room was not being cleaned, staff told her that her room was cleaned, but she couldn't see it. This comment tends to raise a reasonable inference that if charging party's room was not being cleaned as she asserted, that staff knew she had a visual impairment and believed she would not be able to see whether or not the room was clean. This satisfies the third and final element of the prima facie case. When the burden shifted to respondent, it proffered that they have room cleaning policies and that they followed those policies, cleaning charging party's room when required. Then it was up to charging party to show those reasons were not worthy of belief. Charging party had witnesses that stated they observed the state of her room after it was allegedly cleaned by respondent and that it was not cleaned. Respondent acknowledged giving charging party cleaners to clean her room herself, and one of charging party's witnesses stated that she used the cleaners to clean the room because of the inadequate job staff had done that day. Records obtained during the Bureau's investigation showed that cleaning logs did not specifically show that charging party's room had been cleaned on any particular day, while it showed that surrounding rooms had been. With this evidence, charging party was able to overcome respondent's assertions that it cleaned her room in the same manner as other rooms and that she was being treated differently based on her visual impairment. Another type of public accommodations case is when someone is denied services or goods based on membership in a protected class. In order to establish a prima facie case, the charging party must prove that he or she is a member of a protected class, he or she sought to enjoy the services, goods, facilities, advantages, or privileges of respondent's public accommodation, and finally that he or she was refused the services, goods, facilities, advantages, or privileges of the public accommodation under circumstances giving rise to an inference of discrimination. Like disparate treatment cases, denial of service cases employ a shifting burden analysis. So after a charging party satisfies the three elements here, the respondent must produce a legitimate, non-discriminatory reason for refusing to serve charging party. It then becomes charging party's burden to prove why respondent's reasons are pretext or unworthy of belief. The Bureau received a complaint recently asserting denial of service based on disability. In the complaint, charging party asserted her gym membership was canceled after she explained to another member that she has severe allergic reactions to fragrance during a group class, which then prompted the member to get up and move to the other side of the room. Respondent stated that her membership was canceled because they received multiple complaints about her, and the member who moved away from her during class canceled their membership after interacting with her. So in essence, her membership was canceled for the way she was treating their customers and impacting business, not because of her disability. In this case, charging party was not able to show respondent's reasons were pretext or unworthy of belief, and it was a no-cause case. The Bureau has recently seen a number of complaints filed by Native Americans against hotels asserting they were denied services based on race. A couple complaints include allegations that hotel staff denied rooms to residents of the Blackfeet Indian Reservation because they were supposed to be under lockdown due to the COVID-19 pandemic. Another type of public accommodation case we see at the Bureau is where a public accommodation has some type of printed notice that either states or implies that it will refuse service based on a protected class. Of course, such notice or advertisement is prohibited in and of itself by statute, but also such notice can be used as direct evidence of discrimination in the analysis of a case. A Native American man was a regular customer at a convenience store in Billings that had a sign near the cash register stating that it would not accept certain forms of ID for the purchase of alcohol or tobacco. The list of unacceptable IDs included broken or taped ID, expired ID, paper copies, out-of-state ID, tribal ID, and military ID. When the man entered the store in 2016 to buy a small bottle of champagne, he offered his tribal ID to the cashier. He was told tribal IDs were not accepted, and the cashier asked for a Montana driver's license. The Bureau found the posted sign at the convenience store was direct evidence to establish discrimination. Remember that with direct evidence, it then becomes the respondent's burden to prove that an unlawful motive played no role in the challenged conduct. A 2007 Montana law prescribed that tribal IDs must be treated the same as Montana's driver's license. Therefore, the convenience store was unable to show that it had a legitimate reason for refusing tribal ID or that a discriminatory motive played no role. This case went on to the Office of Administrative Hearings, which awarded the man $7,000 in emotional distress damages that he experienced due to the illegal discrimination at the convenience store. The hearings officer agreed with the Bureau that the sign was direct evidence of discrimination, but it also stated that a posted sign announcing that a convenience store would not accept tribal IDs was a statement that it would deny the holder of a tribal ID, who is necessarily a member of that tribe, sales of controlled substances based upon the presentation of that tribal ID in violation of the law. When someone is not denied services at a public accommodation, but they are treated so poorly based on their protected class while receiving services, such treatment would be considered harassment in the area of public accommodation. In order to establish a prima facie case, the charging party must prove that he or she is a member of a protected class, he or she sought to enjoy the services, goods, facilities, advantages, or privileges of the respondent's public accommodation, and finally, he or she was allowed to use the services, goods, facilities, advantages, or privileges of the public accommodation, but was subjected to markedly hostile conduct that a reasonable person would find objectively unreasonable under circumstances giving rise to an inference of discrimination. Like disparate treatment cases, harassment cases in the area of public accommodation employ a shifting burden analysis. So after a charging party satisfies the three elements seen here, the respondent must produce a legitimate, non-discriminatory reason for the challenged conduct. It then becomes charging party's burden to prove why respondents' reasons are pretext or unworthy of belief. A few years ago, a truck driver broke down and had his rig towed to a repair shop in Montana. The truck driver was from Iraq and an adherent to the Islamic faith. During the course of servicing the rig, the truck driver and shop owner's interactions became contentious. The truck driver recorded a video of a portion of their interaction, which showed the shop owner cursing the truck driver, Iraq, and Islam, and telling the truck driver to go back home where he came from. "We don't need you here." This video constituted direct evidence of discrimination, which of course then means the shop owner had to either prove the evidence was unworthy of belief or that there was no discriminatory motive to his conduct. The shop owner proffered that the truck driver instigated the conversation, in part, by threatening that Muslims would take over America, and therefore the shop owner was only responding in defense in the video clip. The Bureau found that there was no evidence to suggest that the shop owner's conduct was defensive, but instead the shop owner harassed the truck driver during its provision of services based on his national origin and religion. Physical touching can also be considered markedly hostile conduct. The Bureau recently had a complaint filed against a large retailer wherein the charging party alleged that an employee who was supposed to be helping her find a product at the store began rubbing up against her in a sexual manner. This was a complaint of harassment in the area of public accommodation as well. It is interesting to note that someone can also file a discrimination complaint if they are treated differently, denied services, or harassed because of their association with a person who is a member of a protected class. This type of complaint is called a by association complaint. An example would be a restaurant refusing service to a white woman because she is married to a black man. Another type of discrimination case seen in the area of public accommodations are failure to provide reasonable accommodations for a disability. The basic elements are that the charging party is a person with a disability who requests an accommodation and the respondent failed to provide an effective accommodation for the disability. If a charging party can establish a failure to accommodate claim, the respondent may be able to put forth the defense of undue hardship. An undue hardship can be in terms of difficulty in implementing the accommodation or the expense associated with implementing the accommodation. Also, a respondent is not required to provide an accommodation that would fundamentally alter its business. An example of a public accommodation failing to provide a reasonable accommodation for disability would be a patient at a hospital with a hearing impairment needing a sign language interpreter as an accommodation. The Bureau also had a case in which a visually impaired woman tried to join a local gym and requested an accommodation for her disability. She asked that a sticker that she could fill with her fingertips be placed on the appropriate buttons on a treadmill that she used so that she would know which buttons to push. The gym denied the accommodation without further discussion or consideration of how putting a sticker on a treadmill would be an undue burden. The Bureau found that the gym failed to provide an accommodation or articulate a valid defense. Another type of failure to accommodate complaint seen at the Bureau in the area of public accommodation involves service animals. A service animal is defined as a dog or miniature horse that is individually trained to provide assistance to an individual with a disability. Emotional support animals are not included in this statutory definition. In one service animal case, a patron at a bar was told his dog was not allowed upon entering. When the patron explained the dog as a service animal, the bartender retorted that his dog was not wearing a vest. The bartender acknowledged during the Bureau's investigation that he had told other patrons to leave if they didn't have papers or a vest for a service animal that entered the bar. The patron in this case was pretty smart in getting the bartender to write down on paper that he was being denied service because he had no proof of his dog's status as a service animal prior to leaving the establishment. After an investigation, this was a cause finding because public accommodations cannot require documentation or certificates that prove an animal is a service animal. It should also be noted that a public accommodation cannot ask that the animal physically demonstrate what it does for the person with a disability. It is also important to understand that in addition to failing to accommodate a service animal, a public accommodation can violate the law in the way it asks questions about service animals entering the premises as well. A few years back, a restaurant told a man seeking service that he needed a vest and paperwork for his service animal to be permitted inside the establishment. The manager made the remark that if the man had a real service dog, he would know the laws. The man then became aggressive and belligerent, using foul language. Ultimately, the man was asked to leave not because of his service animal, but because of his behavior. The Bureau found cause and the matter went to the Office of Administrative Hearings for a hearing. The hearing officer acknowledged that the manager made a good faith mistake in her understanding of the law and what questions she could ask, while also acknowledging that the manager's mistake exacerbated the confrontation that ensued. However, the hearing officer also stated that neither the manager's questions nor the man's disability warranted his boorish behavior. Therefore, partly owing to the man's own behavior and part in the incident, the hearings officer awarded the man only $2,500 in damages for emotional distress for the manager's violation of the law. So remember, public accommodations cannot require documentation proving the status of a service animal, and they are only allowed to ask two questions: whether the service animal is required because of a disability, and to describe the service the animal has been trained to perform. But be cautious, because although public accommodations can ask these two questions regarding service animals, when it's not obvious that the person is disabled or obvious what task the animal performs, it cannot inquire about a person's disability. Also remember that the definition of disability includes mental impairments, so you may not always be able to tell if someone experiences a disability or what kind of task a service animal could perform for someone. Of course, that is the type of situation where it is okay to ask these two permissible questions. There are some additional points about service animals in public accommodations that you should know. According to the Montana Human Rights Act, a person with a disability has the right to be accompanied by a service animal in all public accommodations without being charged extra for the service animal. However, a person with a service animal, whether fully trained or in training, has the responsibility of paying for any damage the service animal may cause. Additionally, a person without a disability is afforded these same rights and responsibilities if he or she is training a service animal. However, by statute, a service animal in training must wear a leash, collar, cape, harness, backpack, or some type of writing that identifies that the animal is a service animal in training, and the identification must be visible and legible from at least 20 feet away. There were some changes to the Montana Human Rights Act in 2019 regarding service animals. The Bureau has not yet had a case requiring a determination about how these changes may affect the portions of the statute enforced by the Bureau, but some of the changes are noted here on this slide. A person may be asked to remove a service animal if it is not housebroken or if the animal is not under control and the person has not taken effective action to control the animal. However, in this type of circumstance, the person must be given an opportunity to stay and receive goods and services without the animal's presence. If a public accommodation posts a sign that animals are prohibited on the premises, it must also indicate on that sign that service animals are permitted. A person who misrepresents an animal as a service animal can be asked to remove the animal from the premises, and local law enforcement may be called to investigate. And finally, misrepresenting an animal as a service animal in order to access a public accommodation with the animal can be a misdemeanor under certain circumstances, where the person has previously been given a written warning regarding the fact that it's illegal to intentionally misrepresent a service animal, and the person continued to misrepresent the animal as a service animal in order to gain any of the rights or privileges afforded to a service animal. Another type of case that can come up in the area of public accommodation is retaliation. It's important to note that retaliation is its own creature, so to speak, rather than a subcategory of discrimination in the area of public accommodation. It is a bit indirectly related. Unlike most other forms of discrimination, the person being retaliated against does not have to be a member of a protected class or associated with a member of a protected class. Here you see the three elements that constitute a prima facie case of retaliation. Retaliation is when a respondent takes a significant adverse act against a person because he or she engaged in a protected activity. Protected activities include opposing or objecting to discriminatory acts, participating in an investigation or case of discrimination, and requesting an accommodation. For example, if a customer complains to a restaurant manager that they don't like that their friend was denied service because of their disability, the customer has opposed disability discrimination and engaged in a protected activity. Likewise, if the friend files a complaint against the restaurant for being denied service based on a disability, and then the customer acts as a witness in the friend's investigation, the customer has then engaged in a protected activity. And lastly, if the friend with a disability asks for a reasonable accommodation from the restaurant, such as the use of a service animal, the friend has engaged in protected activity. When determining whether or not the charging party was subjected to an adverse act, the question revolves around whether or not the act may dissuade a reasonable person from engaging in protected activity again. Continuing on with the example just discussed, if the manager of the restaurant kicks out the customer complaining of the discriminatory acts against his friend simply because he complained about the discrimination, the manager has then retaliated against the customer. It is reasonable to think that being kicked out of a restaurant could dissuade the customer from speaking out again against discrimination. The last element requires a charging party to prove that the adverse act was taken in response to the charging party engaging in a protected activity. If the charging party is successful in proving all three elements, he or she has established a prima facie case of retaliation. Just like under the disparate treatment analysis we reviewed earlier, when a charging party establishes a prima facie case of retaliation, a shifting burden analysis is used, requiring the respondent to provide a legitimate, non-retaliatory reason for the adverse act. The burden then shifts to the charging party to ultimately prove that the non-retaliatory reason proffered by the respondent is pretext or unworthy of belief in order to prevail on a claim of retaliation. Now we have concluded going over the various types of complaints in the area of public accommodations. One last thing to be aware of is that there is a statutory exception carved out of the public accommodations statute for treating people differently based on their age. Public accommodations are permitted to give special benefits, incentives, discounts, and/or promotions based on age. And of course, examples of that are early bird or senior discounts that you can get at a restaurant. I've also heard of grocery stores that give a percentage discount or double coupons to customers over a certain age on certain days. And this type of disparate treatment is A-OK under the Montana Human Rights Act. To learn more about discrimination or the Montana Human Rights Bureau, visit our website at www.montanadiscrimination.com or give us a call toll-free at 1-800-542-0807 or locally at 406-444-2884.